sometimes engineers don't realize that they have a patentable activity. And again, patent could be used as a shield as well as a sword. In the United States, in the United Kingdom, there's no thing called moral droit. Sin of outsourcing companies using the same stuff that is no longer theirs. All right, so ultimate price of mistakes. So, everybody makes mistakes in life, in personal life, in business. So what are we losing? So you can lose rights. You can use actual technology. So your source code is leaking. You lost opportunity. So you had an opportunity, as Arthur described, you messed up somehow. You actually lost your friends, you lost your contacts. And sometimes in the business, I've been witnessing, many companies, many tragedies when, the guys work together for 15 years and then, the worst happened. They actually made money and they couldn't divide it. When they were like struggling working on credit cards, they were fine. And then they, instead of the one great client, I had one client that could write like the best code in the world, and the other guy that could sell anything. Like he would sell snow to Eskimos, but neither of them could do the other thing. So instead of one good client, I got two poor ones. So you could lose reputation, you could lose confidentiality, privacy, both in business and private life. You could also use exclusive use, meaning that you had an opportunity to use either certain intellectual property by yourself, but no longer use it by yourself. Goodwill of business or trademark dilution. So you could lose time, you could lose money, but in my scale at the bottom, I put failure of success, and that's what to me is the most tragic. Most of the businesses that fail, they have a crappy product, right? They started in just crappy product. It doesn't work. But to me, the worst thing is when there's a good product, but it's failed. And fail for other reasons other than the product. And so this is what we're going to talk about today. And what I've been witnessing is essentially survivorship bias. So for those of you who know what survivorship bias is, there was a guy during World War II that was invited. He was a statistician, and essentially he was asked to provide, raise hands who know what survivorship bias is. Okay, survivorship bias essentially started with Mr. Wald. He was told to reduce the number of losses for the bombers during World War II. And so the bombers were coming back in and they had holes in them. And so, and people in the military usually say, okay, so here's a hole in the airplane, so let's put more armor into it. He did the opposite. He said that you should put more armor in the places that had no holes in it. Why? Because basically, if you see the hole in the airplane actually came back, but you don't see those that got lost. So meaning that if, let's say, this particular place, all the airplanes coming in and there's no holes in it, means that somebody who got hit in that hole in that place lost in the field. He was able to reduce the losses by like 40%. So counterintuitively, right? Patching, but not patching the holes, actually patching things that allegedly were basically the most vulnerable places. And so legal mistakes, main spheres. So corporate formation. These are the areas we're going to go over today. So copyrights, trademarks, patents. I'm barely going to do patents today. Patents is a very specialized area, but essentially, Microsoft was filing about 20,000 patents per year. So, and sometimes engineers don't realize that they have a patentable, invention. But actually, patents sometimes, even though expensive, it's a good place. But people invented things such as toilet paper. And by the way, the toilet paper, if you look at the actual patent, the paper goes on top. So if your wife says otherwise, you could basically present a patent saying, "Listen, honey, I could save the family this way." And some of the patents that I've seen, like in the end of 19th century, people were afraid of being buried alive. So one patent was invented that it actually had a hole and a pipe and that goes into the coffin. And so if the undead person, wakes up, he can essentially, ring the bell and being saved. So this one of the patents. So, well, the story, long story short, is sometimes engineers don't realize that they have a patentable activity. And again, patent could be used as a shield as well as a sword. Business methods, don't do it. Sometimes people say, "Oh, I'm doing, selling kittens on the internet." These are business methods. Don't do it. And it could be abstract. So all the software patents have to be reduced in practice, somehow attached to the hardware. And so European filings typically extremely different from patents in the United States. I mean, we have everything bigger and better in the United States. But patents in Europe are extremely just different from patents that are done in the United States. So sometimes people do cheaper patents, in Ukraine or Poland, and try to translate them into US. It just doesn't work. These are worthless, basically pieces of paper and contracts. So we quickly go, and again, this is not a comprehensive lecture. This is basically, again, survival bias. We're looking at the most vulnerable places, which in my view have happened. So the first one we're going to talk about is copyright. So what is copyright? It has to be original, it has to be fixed, and it has to be minimum level of creativity. So these are the three basically features of copyright. And so what does it protect? It protects code, graphics, characters, and obviously, as soon as Mickey Mouse is about to retire, you have a new law extending his ability to work and make money. Rules of the game? No. Language? You embedded the language? No, it's not. Okay, it's not protected. Ideas? Barely. So, for instance, a Gone with the Wind. No paper book popular. So there was a lady that actually rewrote the same book, not even using any words of that book, but from the point of view of the slaves. And it was Wind All Gone, something like that. I forgot the name of it. And so even though it was original, it wasn't even copied. It was still deemed to be a copyright violation because of the characters. The characters were imaginary. So if they were to use characters in real life, then might not be violation. But basically, because characters themselves are subject to copyright, that was deemed a copyright violation. So in one of the things that for those of you who do business in Europe, in the United States, in the United Kingdom, there's no thing called moral droit. So moral droit, even though it's a French word meaning moral rights, and that's not what you think about French, but essentially moral droit means the copyright owner have certain rights that he cannot sell or assign, he or she. And there are four certain rights, and they look very ominous, particularly for people that do outsourcing business. For instance, if you order something in Ukraine or Poland, a Ukrainian developer technically can come back and buy back his own authorship by paying fair price. So all the Microsoft that has been done by Indians will come and say, "Oh, here's $2 billion, give it back to me." So Americans are very afraid of the moral droit rights, and these have to be waived, even though they might not be enforced in Europe. In Europe, they think that moral droit are like human rights. So I'm the author, and if I wrote War and Peace, I'm always the author of War and Peace, and I can always return it back. And so one of the biggest things in software development and licensing is a thing called self-plagiarism. And so basically, how could you self-plagiarize? How do you plagiarize yourself? So let me give you a little bit of an example. So for those of you who listen to rock music, you know John Fogerty, right? Creedence Clearwater Revival. Heard of him? Okay. So he wrote, so if you want to learn, for those of you who are not Native Americans and want to learn all the curse words in English, type Fogerty in Fantasy Inc. and see how Fogerty refers to Mr. Zion's, all the things that could not be repeated with ladies present. So essentially, he wrote a song called "Run Through the Jungle." Everybody knows it's a very famous song. It's an anti-war song, and it was. The problem is that he's basically his contract was so terrible. It was so basically unbalanced that he gets almost no money for the next, like, I think 14 years or something like that. He was so upset when he realized what he signed. For 14 years, he didn't write any songs. I mean, imagine that, we had like one of the most gifted artists and he just like, screw it, I'm not doing it if I'm giving it away. So he wrote the Run Through the Jungle. And then in 1984, 14 years later, he wrote a song, which is called Old Man Down the Road. We're not gonna have much time, but you can listen to both songs. And actually, I usually do like a little bit of a jury question, whether it's the same song or not. And people feel like in our yesterday's election, very strongly about whether it's the same song or a new one. And so, believe it or not, the litigation lasted for a long, long time, for 10 years. And legal fees were over $1 million. And he actually had to perform even song on the witness stand and showing that it was not the same song. But again, the essence of the court case is that he copied, allegedly, that was the science and fantasy, his own song.
Yeah.
Right? So that was the violation. They said, this song that you wrote looks very much like the song you wrote, but we own that song. And you wrote a song that is very similar. So that's actually what happens sometimes with software development companies, is that I use that as an example. They would develop something for a hospital as a work for hire, and then they turn around and do another hospital. I was like, guys, you can't use this code. Self-plagiarism. You use, instead of doing work for hire, say, listen, I'm not going to do something from scratch. I have something in my pocket. So instead of $300,000, I'll charge you $250 for exclusive license. You're going to use it. But, and if you decide to do a red button, I'll do the red button only for you. No other hospital will do the red button. But the biggest sin of outsourcing companies is using the same stuff that is no longer theirs. So remember John Fogerty. So copyright, it actually, so if you wrote a book, a song, a source code, so it's actually your rights in that original work of authorship is automatically, but still put a notice. It's not going to hurt. And why? So you kind of put a warning and you tell other people that it's yours, and so it makes it willful. People sometimes, one of my clients literally copied a picture of a mouse. I mean, the computer mouse. I'm like, okay, just take a picture, because the Getty, the trolls, they put all the pixels and they kind of trace all their pictures on the internet, and we have to pay like $4,000 just to buy out the guy's studio mouse. So, but still register. So if you have something that copyrightable, register. So why do you register? Presumption that you're the author. So if you have a scrupulous employee, he runs away and steals it from you, you could always prove that it's yours, because kind of, you match. Proof and evidence. So you compare to the violator. I have a war story. So if you remember, there were games related to like farms, and people do like farming and all the strategy stuff. So actually, one of the employees of our client left, and he took and stole the code, which we were sure of. But we wrote a little bit. The green is not as green. The grass is different. The tractor is different. But he was the animator that drew the cow. So he really loved the cow. So he actually left the cow as it was. So we wrote to iTunes and said, listen, it's a copy. And look, the cow looks the same. So they actually shut down his account. So that's where we threw the cow at him. But again, that's how you protect yourself. Another one, not to disparage any lawyers in the room, payment of the legal fees. So if you have a registered trademark and copyright, you get your legal fees back. Statutory damage. You don't know how much somebody violated your copyright. you can actually tell the judge, listen, I don't know what it's worth, but just give me $150,000 per violation. Not bad, right? So when a couple of years ago, if you remember, little girls were sued for millions and millions of dollars. So what it means is they were downloading songs. So each download was a violation, $150,000. So $150,000 per violation reach. So biggest problems, unintended co-owners. So if you hired somebody to write a song or write a script or anything for your site, and you didn't have a work for hire language, he or she becomes a co-author with you. So I call it the problem of hungry student. So you get a student like, oh, write me the script. He writes it, you put it in your software. You just became David Gilmour and Roger Waters. You wrote one song together. It doesn't matter who wrote more or less, you're 50-50 now. Unless, of course, you said work for hire, which you wrote is mine, and you don't claim it. And also, who owns derivatives? So derivatives is a big problem in the IT industry, because sometimes you could be inspired by or you copy. And that's unfortunately a kind of a question for the jury. And we will go over derivatives a little bit later again. So quickly, for basically people that are following modern trends in AI, there was a very important case last year that happened, not related to AI, but will have a huge influence on AI. So fair use. So basically, if you take somebody's copyright, there are things you can do to it without asking the permission of the author. For instance, you don't want to spoil somebody's book. You photocopy and take it with you on the plane or read, from papers. So there's a lot of, or blind people can do interoperability for the language for the blind or for the deaf, deaf people and stuff like that. So what happened is there's a transformative use also. You take somebody's copyright and you transform into something new. Let me give you an example. So, you know who Andy Warhol is, right? That's his most famous sort of art. Somebody said it was famous sale, but let's pull it on. So these are so there was a guy named Goldsmith. He took a picture of Prince and did series of pictures, and they were sold to a magazine. Then, of course, Andy Warhol comes in and transforms it into a work of art. So there is actually a case. Was it transformative enough? So Andy Warhol's art is something that is new. Did he take something and transform it into a new work of art or into a work of authorship? And the answer is, so Andy Warhol actually became, in the eyes of the Supreme Court, the greatest salesman of all time, but not the greatest artist. So, and I think this case will present and will show that, when you have ChatGPT and creating whether pictures or text or other stuff, it will have a big influence on what is copyrightable now. And in the United States, something that created by a robot is not copyrightable. But in China, they already copyrighted an image, a character, like a semi-cartoonish character, a beautiful girl, and call it a copyright, though it was 100% creative. So this is an evolving area of law and business, and we have to be aware of that. So area 2. Any questions about copyright? We could do later if you have. Level 2, trademarks. So basically, copyright you can only breach by copy. And the extreme case is George Harrison wrote a song, My Lord, Sweet Lord. Everybody knows George Harrison, right? Do you guys know who chiffons are? I didn't know until I read the case. So Chiffons was a disco group that wrote a song and claimed that My Lord Sweet Lord was a copyright violation. And George Harrison said, guys, I'm Beatles, one of, I don't listen to disco. I can't copy. But in order, so it was like 4 or 5 notes that allegedly in that song was repeatable. And so for the judge to find violation, he had said, well, you might have gone to limo and radio everywhere, so you must have listened, and accidentally it was reflected in your mind, and you copied it. So, lo and behold, copyright can only be violated with copy. So if 2 guys are sitting in different rooms and never seen each other, wrote the same thing, no copyright violation. Trademarks, however, is you have to be careful in choosing what you do. So basically, trademarks, no need to know about each other. So if you woke up and decided to call your company Google, it's not going to help you that you were ignorant for the past 25 years. Trademark. So trademark in the United States could be used or could be intended to use. The United States is one of the countries that allows you to register, not even register, apply for registration and receive so-called notice of allowance, which means you can have a priority on certain trademarks even before you start using. If you sell BMW, that's a car, and it's BMW or Gucci perfume or whatever, that's a use. Similarly, for instance, Klik. If Klik sells basically software development, that's services, that's use. You could also trademark also is a market concept. So actually, it's a geographical concept. But in the United States, you could register trademark for the entire United States. But when McDonald's was developing its brand, went around the country, started buying all the moms and pops McDonald's, restaurants, making sure they don't have a priority. Because if they were there, McDonald's restaurant, 50, 60 years ago, they might have basically interfered with the use of the trademark. So basically, it's a market concept. So market is not just geographical. For instance, there's Apple computers, obviously, but also applications. So then they don't intersect. So there is a market concept. However, you cannot call yourself Adidas software because everybody knows Adidas. It's a huge mark, or Gucci software. So there's actual international treaties preventing you from using well-known names. So quickly, we're going to go how to choose whoever is going to be interested in that topic, whether you're on the verge of forming a new company, or if you think of rebranding, or whether you want to protect your company. We published an article called How to Choose a Name for Your Product and Company, and I'm happy to share it with you. So there are 5 actual legislative types of trademarks, and we, claim to fame, I think we invented the 6th one, congestion. So generic, descriptive, suggestive, arbitrary, and fanciful, and congestive. So let's go quickly over the concepts. So how to identify what kind of a trademark and name you have. And you could breach by being confusingly similar. So what is confusingly similar? So if you do Google, but you spell G-U-G-L-E, you still confusingly similar. So if it sounds like, and there are about 8 to 10 different factors that would apply to see the sort of whether a consumer will think it's the same. It's really, trademark is a funny property because it's not really designed to protect you. It's actually designed to protect the consumer, who's supposed to know the source of the goods. So registration. So why register? Easy proof, shield and sword, demand, cease and desist. If you have a registered trademark, easy to send to Google or Apple. And again, treble damages. So if you show that somebody makes sales of your Gucci shirts for $100,000, you say, okay, $100,000, pay me $300. So it's treble damages automatically almost. And again, you get your attorney's fees for the registration. So quickly, different marks. So generic and merely descriptive. So almost never protected. There are very few exceptions, like TV guide. You know, nobody knows what TV is, God forbid, guide. But, you know, 10, 15 years ago when you were going through the store, you saw this little booklet and it would have a red TV, it says TV guide. I mean, what else could be more generic, more descriptive? However, when we, at the time, we say TV guide, we identify with specific, you know, book. It's like Facebook, it's most likely a generic descriptive. But again, let's say Facebook, now there's a secondary meaning. People think about Facebook, not from high school Facebook, but the Facebook on the internet. So whether it's link builder, best lawyer, I'm sorry, well, bestlawyer.com I misspelled because best lawyer actually spelled the way it's spelled on the right side of the screen. And then a storage review, password protector, channel monitor, my fitness coach. It's actually, all these are real projects, real trademarks that, you know, I kind of borrowed. So really terrible idea. The thing is, like, if you become popular, you can't protect other people from using it. That's the point. It's not that you can't use it. It's like you can't make other people not use it. My fitness coach, probably initially merely, if you use something like your last name, and I heard that Klik origin was Olshansky. So don't use Dell, you know, McDonald's, or Kaspersky, or Schwab, all bad names, trademarks. Good last names, but bad trademarks. But because of the marketing, you transfer it again into secondary meaning. So when you make something into, basically, when people understand that it doesn't relate to basically a last name, but it relates to a product, then is okay. But that basically costs you maybe millions, sometimes billions of dollars. So don't do it. Basically, again, Facebook probably requires secondary meaning. And suggestive are probably one of the best marks possible. So for those of you who remember what burning CDs are, and CDs, you know what CDs are. So narrow, burn, wrong, right? CD-ROM burning software. So suggestive means you have a mental bridge between what your product does and the name itself. Stiff nipples. Okay. Air conditioning service. Okay. So and actually, I found it in Italy. Only Italians could, you know, get that concept. Again, name, but you need to do a certain bridge to get to the product. Now, ladies apologize, but you know we had a man volunteer, which was fine too. So Hawkeye, tennis ball cameras and software. Again, Hawkeye, tennis software, Under Armour. You know, being in Maryland, perfect suggestion. War Thunder games. Again, there's enough of reference to get to the game what it is, and so they are fully protected. Fanciful. What's fanciful? Fanciful stuff you just made up. So Kodak, Xerox, Exxon is basically non-existing. 100% protected. The problem is that nobody knows what the hell you're doing until you actually get the message to the consumer. Okay, so arbitrary. What's arbitrary? Bluetooth, BlackBerry, Hootsuite. So arbitrary means Gibraltar software. So you take the word, but it has no relationship to your product. Protected. So fangestive, the thing that we invented. I mean the word description. Beacherella. So it's the word that doesn't exist. Well, you kind of know what it is, right? Like, you know, umbrella for the beach. Beatles. So it doesn't exist, the word itself, but it's beat, you know, and there are a bunch of, you know, Beatles running around over the stage. there was actually a metal band, I think we're using the same method, so the vol beat. So volume, beat, and then you have the band. Sherp, one of our clients, it's one of the Ukrainian vehicles, so Sherpa, they took out A. You kind of have still the reference to the same concept. You know, it's basically a guy or a car that goes anywhere, but again, without using the actual word. Meter. So for those of you who like really, meter is a temperature gauge for your state. So it's metering, but also for the meat. So it's not an existing word, but again, it kind of gets you the concept. Diligence. So deal and diligence, right? Again, great concept, great combination. And of course, you could have ways, which is, you know, the way you go. And works very well on pages, by the way. And I think Klik, you know, the way it's spelled, can also be the frangestive, meaning it doesn't exist, but has a reference to electronics and industry. So get your creativity up and try to get something like that that will give you 100% protection as well as, you know, impression of the consumers. So this is actually a shirt. For those of you who could spare about $148,000 for the basic model. And that's the meter, which I use, and that's my claim to fame when I beat stakes. So inception of the companies, that's also one of the problems. And basically, if you do a simple company for cutting grass and stuff like that, you know, state makes it easy for you. But all these clerkies, Stripe, helpers, and you know, your company cannot be, could not cost less than your full. So there's a lot of things at the inception of the companies. When you do forms, do it yourself. These are all things that we basically see biting in the butt, you know, all the founders. We just had a case last week. The two guys made a company. One is for holding IP, the other for operations. And two founders, one held one company, another founder held the other. And, you know, the whoever helped them said, okay, just keep one company for the guy. We don't know why, but it was either IRS or his divorced wife that just froze the accounts. And the other guy is out of the picture. He can just count display. Oh, by the way, it wasn't really his company, it was a company that we both own. So sometimes, you know, basically being sloppy in the formation of a company is a problem. And of course, in reality, there's a lot of KYC, location, citizenship, you know, being a Belarusian, for those of you who are studying World War II, being Belarusian in the world is right now is like being a Jewish and German at the same time in 1940. For those of you who made reference to the Ukrainian war, would understand. But still, with the company formation and different nationalities and passports involved, you have to be very careful. So in the United States, right to do business is a God-given right. So you don't really need to register. It's like, why did I even care about the company? So the problem is the right to limited liability is a privilege. It's a privilege given by the government, meaning that you separate your dog, your house, your car from the property of your company. But if you don't keep that separation, you might actually lose and have a personal liability. So basically, you could choose wisely and make sure that at least your company is incorporated properly and in friendly registration. So trust by verify, formation of the board, election of officers, all these initial stuff. What are the duties that you as a founder have? And you actually have only two duties. Shareholders can be greedy bastards. Shareholders can do whatever they want, almost, other than things that are listed in the shareholder agreement. However, as an officer director, you have a minimum level of professionalism, which means when you make decisions, you have a duty of care. So duty of care is a minimum level of competence. So you can't just make decisions. If you make decisions reasonably, whether relying on CPA or lawyer or even your wife, who is smarter than you, I'm sure, basically you have probably fulfill duty of care and might not be liable even if you messed up. So, so-called business judgment rule. In the United States, you're usually not judged harshly for making stupid business decisions. Then you have another duty. It's called duty of loyalty. Now, what is duty of loyalty? If you have a bunch of shareholders, it means don't steal. And if you appropriate opportunity. So, for instance, if you came to this meeting as a business trip from your company, and you found out something about new opportunity, you actually have to bring it back to your company first, the board of directors. Otherwise, it will be appropriation of opportunity. So, essentially, don't steal. But if you just care in good faith, your company will have supposed to cover your legal fees. Okay, so indemnification. So basically, but if you don't, or you don't do corporate formalities, which is annual meetings, resolutions, and actually one of my clients, potential clients, I don't think we hired him, said, well, what if I buy diapers from corporate account? Can I do it? And CPA said, yeah, buy it, I'll just write it as a personal expense and we'll reimburse. The problem is not just taxes, and in fact, CPA can put it as a personal expense. The problem is when you mix up your own pocket with pockets of the corporation, so the outside public do not know where you are and where your company is. So separate yourself from the company. Make sure you actually have a hat that you wear. So shareholder agreement. I don't want to waste too much of your time. Basically, quickly, I think you should be able to have a shareholder agreement. If you have two more shareholders, suggestions, strong suggestion to have it written. Basically, why would you need a shareholder agreement if it's not required by law? So restrictive covenants. Sometimes you might be a minority, a 30% shareholder, and you could say, I want to have a veto over you changing the direction of company or having big contracts or giving loans. So these are major action. You could also, things happen with our company clients. 4 guys were working and one of them literally became Buddhist monk. And so how do you reduce his share? He doesn't work anymore. And everybody's perception was you had a quarter of the company, but not what you've done, but you're supposed to do 2-3 years down the road. So the concept of vesting, meaning that, well, we give you 100 shares, 20 shares you already vested because you've done stuff, but then 20% is vested over time. If you don't work and you became a Buddhist monk, we buy unvested shares at $1 a piece. And so classes, you could also basically separate different classes if you have investors, preferred class. But the biggest thing is drag alongs. So what is a drag along? So this is where basically a drag along is not the instance where your wife drags you to buy Christmas shopping, but it's very similar. You want to sell a company, but one of your shareholders do not want to sell. So his or her shares are actually property. It's like, how do you confiscate somebody's property when they don't want to sell? So we had an instance, and I always make the war stories part of my lecture. I don't make them up. A guy owned 0.5% of the company, but he didn't want to end up, and the company was sold at, let's just make it up, $10 million. He didn't want to end up with 5%. Or, with 0.5%, 50,000. He said, listen, I need much more. So the other shareholders had a choice. You either fold the deal, you don't do the deal, or you pay up the guy from your own share. So the guy got 14 times more on his 50, okay? 14 times. He got $700,000, even though he was entitled only to 50. So what you do is shareholder agreement where you say, well, if 51% of shareholders agree to sell, you agree to sell, and your wife agrees to sell, even though she might have divorced you already. And that's part of shareholder agreement. So disasters, divorce, bankruptcy, boss factor. So what happens if you end up with somebody as a shareholder that you don't want to deal with? You at least have the ability to buy somebody out. And careful, non-compete, non-solicit, particularly if you're in a socialist state like Maryland, non-compete is a problem. For instance, California, if you put non-compete, the entire agreement becomes null and void, not just the provision. If you come to your employer says you left, hey, here's non-compete, the entire agreement, and imagine that this agreement says work for hire, he worked for you, he gave you his stuff. So you took this agreement, throw it away, or burn it. It's no longer valid. In Massachusetts, if you bound somebody to be bound by non-compete, let's say for a year, you pay him half of the salary. So if you throw a non-compete without realizing what kind of consequences, and obviously to protect yourself, not solicitation of customers, not solicitation of suppliers, not solicitation of employees. Again, be careful where you are. So boilerplate is also important. We might go a little bit over it. MSA agreements, custom development. So again, self-ledger is we win. A license when you can. Work for hire is a problem. So I like the concept of red, yellow, and green, like the stoplights. So what red means is that you work for somebody and it's your intellectual property. It's your stuff. So you license it. No work for hire. Nothing. I'm just giving you, Microsoft or Beat, whatever. So it's a license. And then green, somebody comes to you and says, well, but I really need this script on top, I need this, and you develop something from scratch for them, which is work for hire, and they own it. So first stop, you own. Second stop, they own. So time and material and all that. What is yellow? Yellow, when somebody comes in, takes your stuff, but makes you change it to their specs. And the problem is that why I call it yellow, because it could be green, it could be red. Sometimes somebody says, listen, I don't like this green button you have on your software, make it red. Supposedly that button not supposed to be transferred as a title to him. You just kind of make specs. And he says, listen, nobody, in my industry uses red and it's very important. Well, make an exclusive use, but don't give out the title to your stuff. It's like important. And so what you do is custom development is typically based on developer's product. Make it a derivative, make it yours. So you change this button to red, and then you can make it blue, or you could make it purple for somebody else. But if you don't do it, and if you're silent, what happens in your product when you're silent? So it's actually the settings. If silent, it's actually customers. So if customer told you something, most likely you just gave it away. So I'm always pleading with my client, just please, whatever you change in your stuff, and you intend to give it to somebody else, don't give it away. And that's one of the biggest mistakes that my clients do. So make sure choosing boilerplates, and I'm finished in 3 minutes. Be careful where you choose. For instance, Virginia is a rocket docket. It's 9 months. And again, sometimes smaller companies can be bullied by big companies like, oh, listen, 3 years and 4, you're going to die. Well, in Virginia, it's 9 months. So you could actually, lawyers hate it because it's really fast. Standards of negligence. And I think that's important. One of the biggest things that people don't realize, the negligence. I mean, nobody here is, you're doing willful violation if you do IT. So, but each of us sometimes screwed up, messed up. And this messing up is called negligence. So there are actually two basic concepts of negligence: contributory negligence and comparative. So let me give you an example. An old lady drives a car in Virginia and in Maryland, and then somebody hits her from behind. So the car is totaled. The car is $10,000, but she didn't wear a seatbelt. So she hit herself, knocked out her jaw, and the medical bills are $200,000. Okay. So what happens in Virginia? In Virginia, if you're negligent 1%, you don't get any compensation. So basically, it's called contributory negligence. So if she were to wear a belt, she would have caused the damage of $200,000. So the guy that hit her from behind, he would be probably responsible for the car, $10,000, but not for the entire medical bill because she was negligent not wearing the seatbelt. In Maryland, comparative. Well, she didn't wear a seatbelt, but he did hit her, 60%, 40%. So comparative means you compare who is more or less. And that's why there is modern modified comparative, which is like the guy would be responsible if he's 50%, at least 50% responsible. The modified comparative is the guy has to be more than 50% responsible. So if the guy behind hit and the $200,000 damage for the old lady was caused by the guy behind, and the jury says, well, it was more than 50%, then the lady would get either 50% or maybe even the entire recovery, depending on the jurisdiction. And so these are the different jurisdictions. So the orange is the contributory negligence. So North Carolina, Virginia, and then blue is the comparative, and pure negligence, essentially comparative negligence, is California, New York. Is just you literally divide based on the percentage of the people. Be careful with arbitration courts, mutual indemnity, non-compete, as I said, non-solicitation clauses. And also remember, in the contracts, all my clients always write, they're never wrong. And so I always put the loser pays the attorney's fees. So basically in the United States, everybody pays for their own lawyer unless the contract says otherwise. So put in the contract that somebody sues you, you win, then you get your attorney's fees back. And this is the end of my presentation. And I would be delighted to hear questions and appreciate your patience.